Hello and welcome everyone to our panel on state secrecy and the war on terror. Today is Constitution Day, and to celebrate or mark the day, we're having a discussion with three experts on one of the major threats to their constitution over the past 20 years, the use of government secrecy to hide vital information about the war on terror from the public and the implications of that for our democracy. We have three panelists with us today. I'll introduce now. I should introduce myself first. I'm Catherine Hawkins. I'm a senior legal analyst at the Constitution Project on the Project on Government Oversight, and have been working on national security and accountability issues since I graduated from law school several years after September 11th. And in the course of that work, I've gotten to know the three panelists here today, so I'm really excited to be able to host them in this discussion. There's Dan Jones, who was the lead author of the Senate Intelligence Committee's major report on the CIA torture program, part of which was declassified in 2014. Dan now leads Advanced Democracy, a nonprofit that conducts public interest investigations. Bahar Azmi is the legal director of the Center for Constitutional Rights. That's a nonprofit in New York that was one of the first organizations to challenge detention without trial at Guantanamo Bay and to visit prisoners in Guantanamo and provide legal counsel. CCR also challenges discriminatory policing practices like stop and frisk, immigration violations, and other constitutional rights by the government. Shireen Sinar is a professor at Stanford Law School, and she researches the political and legal response to domestic and international terrorism and hate crimes. So I wanted to start with a general scene-setting question for each of the panelists. Where were you on September 11th, and how did it shape the next few years of your life, professionally, personally, if you want to elaborate on that? I guess I'll start with Dan.
Great. Well, first of all, Catherine, thank you for having me. It's a pleasure to be here on Constitution Day and to be on this panel with the other guests. Where was I on September 11th? I had just left Baltimore City, where I was a Teach for America teacher for 3 years, and I had gone to the Kennedy School of Government to study international development under an economist named Jeffrey Sachs. And the very first day of school for me was the attacks of September 11th. I was in a common hall area, and for some odd reason, CNBC, the business channel, was on. And I watched the second plane hit the second tower. And myself, I changed my focus from international development to national security issues at the Kennedy School, as did many other of my classmates at the time. And it eventually led to me jumping to the Federal Bureau of Investigation after I graduated from Kennedy School.
Bahar?
Hi, Catherine, echoing. Thanks for inviting me to this important conversation. I was in Brooklyn it was election day, primary day, helping a friend who was running for city council. And then after the train started running, after 5 or 6 hours, made my way back to my apartment in the West Village. I live a block from St. Vincent's Hospital, which had a line around the block with volunteers planning to give blood. And of course, as we all know, there was none needed to give, and then was sort of living in the below 14th Street kind of war zone that was, had checkpoints and tanks, and there was a real feeling of fear and anxiety for months after that, and then became very seriously involved in the sort of what I would call the human rights crisis created by the Bush administration in response to the terrorist attacks in my work as a law professor and then with CCR.
Thank you.
So I, like Dan, was a student on September 11th. I had just started my second year at Stanford, and actually had just moved from New York the weekend before, having transferred to Stanford at the time. So during the day, I was mostly just in touch with friends in New York as people compared notes about where they were and whether they were safe. By the evening, I was with other members of the Muslim community trying to anticipate and respond to the wave of backlash, hate crimes, and discrimination that unfortunately began quite soon after the attacks. And that is what characterized the rest of my law school experience. I became involved with, actually, even in the weeks after September 11th, helping to do legal education trainings for the local Muslim community. I was getting calls from post 9/11 detainees. I knew nothing as a law student, but I was just trying to connect people to civil rights and legal organizations. And I became a civil rights lawyer after law school, working on national security, discrimination, profiling, and so forth, before transitioning to becoming a legal academic about a decade ago. And civil rights and national security work continues to be my focus.
So I know that all of you have encountered cases where the United States used claims of state secrecy to conceal government abuses. And I wanted to give each of you the opportunity to discuss an example or a story you know well. So I want to start with Bahar.
Mm-hmm. Sure, and I think I think I want to keep in mind that secrecy is an important feature of the post 9/11 landscape, but I think it is just sort of part and parcel of the more kind of fundamental project post 9/11, which is a project of war, detention, torture, and it's a profoundly anti-democratic project. I dare say, at times authoritarian. And so secrecy is a necessary embedded part of this whole project to wage war, detain, torture, and surveil. And I think a prime example that I was involved in is Guantanamo, which was the crown jewel of the Bush administration's global detention policy, and arguably the sort of most iconic feature of the war on terror. And secrecy was, utterly critical to the authoritarian project there. Guantanamo was, I think most people know, was intentionally selected as a place outside of the jurisdiction of the U.S. courts, beyond the law. That's in one of the John Yoo OLC memos. And why? Well, of course, to avoid the sort of legal constraint that would come from the Geneva Conventions, or what ultimately constrained, which is habeas, but also to have a platform, because Guantanamo was never about guilt or innocence or meting out punishment, was a situs to conduct endless, brutal interrogations of Muslim detainees, and to operationalize this, in the words of the CIA manual, a system of debility, dependence, and dread through features, as Catherine has written about, like installing feelings of learned helplessness, making detainees completely dependent on their captors, so they would talk. Detainees were held totally incommunicado. When we were, CCR was in the Supreme Court in 2004. Our clients who were in Guantanamo had no idea they had a lawyer. And it was only after the Rasul decision in 2004 that said the habeas corpus statute did apply to Guantanamo that lawyers started streaming in. And just that kind of incommunicado process was necessary, to break detainees, and also, a feature of it was to ensure that detainees would never, for the lawyers out there, lawyers are often characterized, but lawyers or legal process was the antithesis of Guantanamo, because it would allow detainees to believe that help was on the way when they had to be made totally helpless. And in fact, so when the detention camp was opened up as a result of Rasul, I think what was interesting is releases didn't happen because of court orders in any conventional sense. Releases happened because we opened up through hundreds of individual stories about detainees, narratives of innocence, torture and abuse, and total bureaucratic incompetence. And that's what started and sort of unpacked the lies that were undergirding the detention camp. So I'll stop there.
Yeah, let me just give a little background on some of the things you mentioned in case people aren't familiar or are younger than us all and don't remember living through this at the time. So Guantanamo, as most of you do probably know, is a U.S. naval base in Cuba, and it's a place that the United States has indefinite control over. It's not, but was at the time beyond the reach of U.S. courts. And so in order for detainees to have any access to a lawyer, attorneys with CCR and some former death penalty lawyers filed what's called a writ of habeas corpus, which is an argument that someone is being detained illegally by the government and the court needs to do something about it. And that did open up Guantanamo to the world a bit. When did you first travel to Guantanamo to meet a client?
So I was actually the third civilian lawyer to visit a client in October 2004. The decision came down in, I think, June 28th, 2004, and CCR and other lawyers organized. I wasn't at CCR at the time. CCR actually was responsible for recruiting and training and coordinating what ultimately came to be many, many hundreds of lawyers representing all 779 detainees, which I think was a powerful way to democratize the challenge to this form of authoritarianism, spread it across civil society and other lawyers. So I visited in 2004 with my client, Murat Kornaz, who was a then 24-year-old Turkish citizen living in Germany, born and raised in Germany, and just sort of, we got to meet in person, and it was a really sort of moving experience for me. He had never met a lawyer. Sorry, he had never met anyone who wasn't an interrogator or, military police. So I brought in this handwritten note from his mother in Turkish, which felt like it was one of these moments, it was a very short note. You'll be visited by a lawyer you can trust. Your brother goes to school. She mentioned that she had seen his then wife and she is loving you. And it felt like at that moment, there was a little bit of as his face shifted and he noticed this was real and there was some possible light coming through, just a bit of a shattering of this matrix. And his story, Catherine, if you want me to talk about the classified evidence that was withheld from him that proved him innocent, or the absurd, preposterous guilt by association claims that they made to hold him, I can, but I've been talking for a while, so I'll stop for now.
We might get to those later.
Okay.
Okay, and then Dan, wrote, so my organization, the Constitution Project, wrote a large non-governmental report on the government's treatment of detainees after September 11th. Dan, at the same time, was working on I would say, a much more intimidating effort to tell the story of the CIA torture program using classified evidence and then to get the report declassified. And Dan, I wonder if you could talk a little bit about that experience.
Sure. So maybe just in the interest of what you said about stepping back for those who maybe didn't live through this period or remember it in some detail. The Senate Intelligence Committee was largely locked out of oversight of the CIA's detention and interrogation program while it was active. It came to light in 2007 that the CIA had destroyed interrogation videotapes, and that opened up the ability of the committee, the Senate Intelligence Committee, to start gaining records to find out what would have been on those tapes, what would have been on those interrogation tapes had they not been destroyed. General Hayden, who was a CIA director at the time, was called to the committee and was asked by the committee, was this destruction of evidence? And Hayden said, no, we have written records of everything that was on those tapes. And if you want to see those records, you can do so. That was in December of 2007. It wasn't until May of 2008 that the CIA actually allowed the committee to review those records. There were restrictions placed on those reviews. It could only be a select number of Senate Intelligence Committee staff. So I was one of a handful of staffers who were allowed to look at these records. We could only look at those records at CIA headquarters. We could not have possession of those records or look at them in the classified Senate spaces. Perhaps, but most egregiously, they were extremely heavily redacted. Again, these records that would have been on those tapes. In any event, myself and a Senate colleague produced a report and presented that to the Senate Intelligence Committee the following year. And it was essentially what would have been on the tapes had they not been destroyed of the CIA interrogations in a period of time in 2002. The presentation of that testimony to the committee led to a 14-1 vote to launch a far larger investigation into not just this period of time that included when the tapes were destroyed, but to look at the program as a whole. Eventually, the committee was provided with 6.3 million pages of CIA's internal records. The committee itself, the staff, took about 7 years to complete all told and produced a near 7,000-page report. And the vast majority of that remains classified. In December of 2014, a 500-page executive summary, partially declassified, was released by the U.S. Senate after many months of negotiations with the Obama White House and the CIA over redactions. And I think that's what, just to kind of bring you up to speed, what Catherine asked me to speak about was the process of declassifying and releasing that report. In August of that year, of August of 2014, is when President Obama gave his speech that many people who track this program remember, which is, we tortured some folks. And then, of course, what he said later after that was, but, it's important not to be too sanctimonious because these people were real patriots. He gave that speech in the beginning of August because he believed within hours the Senate Intelligence Committee was going to be releasing an executive summary of its study. That executive summary, after many months, was redacted almost completely by the CIA. There's a section, for instance, on Khalid Sheikh Mohammed that was all black. There was literally the entire story of Khalid Sheikh Mohammed's detention was redacted. Unbeknownst to the President of the United States at the time, when the committee received that report back, it decided it wanted to challenge the administration on what should or should not be declassified. And just a little talk about how that process went from August to December. In the regards to the Khalid Sheikh Mohammed declassification exchange and back and forth between the committee and the White House, and I say the White House because ultimately they controlled classification, even if they were passing it off to the CIA to do. One of the tactics that we used to push on declassification was to identify things that were already in the public sphere. even if the US government hadn't officially acknowledged it. The most effective way to get the Khalid Sheikh Mohammed aspects of that declassified was we brought in books written by former CIA officials, including Hayden and others, and most specifically, as I recall, a CIA officer called Jose Rodriguez, who wrote a book, and we showed them their book. The book wasn't redacted at all, and it tells the story of Khalid Sheikh Mohammed. Some accurate information, but mostly inaccurate information. And we compiled this large canon of material that former government officials were able to release and push out publicly, but it was all false and incorrect. And I think eventually we as a committee embarrassed the White House into allowing additional information to be unredacted in Khalid Sheikh Mohammed's case. Another example of where state secrecy was a problem. The International Committee of the Red Cross visited, eventually gained access to some CIA detention sites. A report was leaked to the press and published, believed by the New York Review of Books, if I recall. And Hayden came up, it was other CIA officials, I believe. It was maybe Michael Hayden and others, and said, this report's not true. You can't believe these people. This was shoddy investigative work by the ICRC. But if you look at our report that's been declassified, when we actually looked at internal records, when that report was first provided to the CIA, there were a number of exchanges where CIA officers were saying, oh, this is actually pretty good. This looks pretty accurate to me. So there was an internal agreement with the International Committee of the Red Cross findings. And then, of course, when it was made public, the CIA testified to the committee and stated publicly that, in fact, it was not accurate. So it really took the committee's efforts to do this near 7,000-page report, and then, of course, get 500 pages declassified to really push back on what would be still today misrepresentations by the U.S. government.
Thanks. And there are two Supreme Court cases this term where the court is going to hear arguments by the government to expand what's called state secrets privilege, where the government tries to get a civil lawsuit thrown out by arguing that the subject matter is just too secret, and for the courts to hear this case would endanger national security. One of them is about the CIA torture program, and the government is specifically trying to prevent disclosure of information that's been in the public domain for 15 years about where one of the CIA's black sites was in Poland. The other state secrets case is called Fazaga versus FBI and involves FBI surveillance. And I think, Shireen, could you explain to people a little more about that case and what's at issue there?
Yeah, absolutely. And I think it's actually important to focus on this case because it shows the pervasiveness of surveillance and profiling within a US context and its effect on American Muslim communities. So the kind of FBI surveillance that was challenged here is reflective of broader patterns of surveillance by the FBI, by the New York Police Department, and by other law enforcement agencies within the US. It's important to recognize that it is Guantanamo, it's torture, it's programs, drone strikes abroad, but it's also surveillance within our own communities that has spawned that's part of the war on terror and involves assertions of government secrecy. So this particular case, Fazaga, goes back to 2006 when the FBI hired an informant who was tasked with conducting surveillance within the Southern California Muslim community. And the informant pretended to be a convert to Islam and for more than a year visited mosques and homes, befriended imams, secretly recorded hundreds or thousands of hours of conversations from a camera in his shirt button and from a key fob that he would leave lying around. And he essentially tried to get people to say things that might get them in trouble. Several community members actually reported this informant to the police and FBI because he was going around trying to incite violence. And the mosque sought and received a restraining order against him. When it came out a couple years later that he had been an informant, the government claimed that it was targeting particular individuals in a counterterrorism investigation. But the informant himself said that he had been tasked with essentially sweeping up information about the Muslim community, about local Muslims, their behaviors, their activities, their points of view, because the FBI agents who had given him this mission saw Islam itself as a threat to the US. So ultimately, several people sued the FBI, arguing that the surveillance was unlawful and discriminatory. And the government sought to dismiss the case on several grounds, but including that it invoked the state secrets privilege. So it said it couldn't defend against the claims without revealing secrets that would endanger national security. And they further claimed that they couldn't even let a judge see the secret evidence to make the decision about whether that was right. It was essentially the government's unilateral designation of the information in question as state secrets. The Ninth Circuit ruled that the court could have used a special procedure under the Foreign Intelligence Surveillance Act to examine whether the surveillance was lawful, involving essentially showing the underlying information to the judge, not to the attorneys, not even to the public, but essentially just to the court itself. And the government argued that it shouldn't be required to do that under the state secrets privilege. So that, without going too far ahead to the exact legal issue before the court, that is the question here. It's whether the state secrets privilege can be used to prevent a case challenging government surveillance and religious profiling in a US community to go forward, or whether the government has to take the minimal step of showing the information to a court to have them have some role in deciding whether that information would indeed present a threat to national security.
And so the state secrets privilege, this argument that this information is so secret that even the sky will fall if the court looks at it, if the lawyers with security clearances arguing against it looks at it. So that's one way the government can use secrecy and its national security powers to prevent a court from looking at whether what it's doing is legal or not. There are a number of others, and I wanted to know if Bahar and Shireen, who both either lived this or studied it, or both, could explain what some of those other ways that the government can sort of close the courthouse doors to people who are trying to challenge what it's done in the name of national security.
I can start, Serena, and then you can fill in, because there's so many. I'm sure I'll leave them out. I think it's a good question. It makes me think that as with all of these doctrines, I'm just so skeptical about the merits of their articulation, like be it whatever justification comes forward, like state secrets. I think, which is often preposterous, and this need that we need to sort of have to, it's what the Biden DOJ says, we have to defer to the national security judgment of the CIA director. Why in a democracy do we have to defer to that reflexive, self-serving judgment? It's just, and I think this is just a way of the executive branch communicating to the courts that you should not hear this case. And there are other doctrines that similarly communicate this protection of white elite decision makers from accountability. So one example of that is a case that CCR brought challenging the post 9/11 sweeps and illegal detention of Muslim men directed by high-level officials, including then Attorney General Ashcroft, then FBI Director, Bob Mueller and the then INS director. And under this theory that's called Bivens, that that had in some circumstances allowed individuals to sue federal government officials for violations of the Constitution directly for damages. And the Supreme Court says there will be no such suits for high-level decision makers engaging in policy decisions involving national security. And this is one of 3 decisions absolving John Ashcroft of any responsibility for his role. Is it about the merits of the doctrine? Is it about sort of protecting the national security state from scrutiny, and then the court somehow implicated or invested in it? There are other doctrines like the political question doctrine that says, that's a little bit more grounded in traditional law, that says certain questions that are adjacent to national security or military are considered political. They have no standards by which you could adjudicate the claim. That surfaced in 2 of our suits around targeted killing of United States citizens, one in which we tried to get with the ACLU an injunction preventing the assassination of Anwar al-Awlaki in Yemen, and another morbidly, which was tossed out because of the political question doctrine. We have to sort of think about military judgments in deciding whether or not he was entitled to due process before taking his life. And another morbidly filed after the assassination occurred of Anwar al-Awlaki, and a couple of days later, his son in a different location. Those were tossed out for the sort of national security reasons as well. And it's hard to show standing to bring a case in the surveillance world. And at this point, I'll turn it over to Serene, because she's been thinking about this a lot, obviously.
Yeah, I think just to follow up on Bahar's point, there are any number of doctrines that the court cites, but sort of to the same effect of declining review in a case where the government asserts that national security is at stake, or deferring to the government's factual conclusions in a way that it wouldn't ordinarily do, or examining a case, but under such a lax legal standard that it essentially, involves the court saying we can't second guess the court's judgment on something. And, we saw that in, for example, the travel ban case, where the Supreme Court, permitted the travel ban and essentially refused to consider whether anti-Muslim animus was the real reason for the policy, because it had gone through this Trump administration review process. So in that case, it was essentially a scenario in which the government said that in the area of national security and when it comes to people entering the country, the standard of review, its willingness to look at and actually examine the claims, the assertions of the government was going to be much less than in some other area of our law. And to take up state secrets, since I began with that point, historically, the state secrets privilege was used as a scalpel to exclude certain evidence from a case, but not in the way that it has been often used now, which is as a bludgeon to essentially dismiss cases altogether from court. And I see that as part of this broader move to get courts out of the picture in cases alleging national security interests. And Bahar mentioned also standing. That's been another significant one. The court some years ago had a case involving a challenge to a surveillance program and determined that the human rights organizations and others who were challenging the program didn't have standing to bring that challenge because they couldn't show that their communications had been surveilled. And of course, the conundrum is that, a surveillance program by definition that is covert doesn't inform the people involved that they are under surveillance, except under certain narrow circumstances. And, essentially by saying that they had no standing to challenge the program, the court was not able to get to even a determination of any of the legal questions. But the last point I just want to make here is that it's not just that national security deference is a problem in terms of diminishing accountability or the opportunity to subject government decision making to to constitutional review. It's also that the harm falls particularly on racial and religious minorities, of the groups that are most likely to be perceived as a threat. And so if you think historically about Japanese American internment, or you think about the relentless focus on Muslim Americans as a terrorist threat, alongside the neglect of white supremacists and the potential for white supremacist violence in the last decade or so. Communities within the US are not equally branded as threats to public safety. And so when courts then choose to defer on national security, the fallout ends up being primarily on the racial others who are often the primary targets. There was a point at which the Supreme Court believed and expressed the idea that courts should actually apply greater scrutiny to cases involving minority communities facing prejudice. And the idea was that minority communities facing general prejudice aren't going to be able to rely as much on political processes, on Congress, on legislatures to protect their rights. So they particularly need courts to look carefully at their cases. But national security deference does exactly the opposite. It strips protection from the groups who need it the most.
So apart from the state secrets doctrine, which is specifically a way that the government tries to throw out court cases because it argues the information is too secret, and the other national security differences, there's the decision to classify evidence in the first place. And I wanted to talk to Dan a little bit about the classification system and how it works. So Dan is one of, so no one was really ever prosecuted for the CIA torture program, including for the destruction of evidence, for abuse of prisoners, even in 2 cases where prisoners were killed. I know of 2 people who the CIA tried to get criminally prosecuted for investigating the torture program. Fortunately, very fortunately, in neither case did it succeed. But having a security clearance and access to secret information puts you at risk of prosecution if you disclose that information in violation of your agreement with the government to keep it secret. So I wanted to, Dan, first of all, could you tell the story briefly of the CIA's search of the Senate computers in an attempt to refer Senate staff for prosecution?
Sure. Well, let me just start by saying, as somebody who has dealt with classified information from when I first entered the FBI, and then nearly 10 years in the Senate, it is very important that you don't make the rules over classification, but you have to adhere to them. So there was never an argument in our case that anyone broke a classification rule. Mm-hmm. The fact that we did push back as much as we did, again, I think, as I mentioned, this August version of a declassified executive summary versus the eventual December version of declassified summary, that was very much the committee working behind the scenes as the process is supposed to work to further declassify information that we felt was inappropriately redacted, right? Inappropriately classified. And I have to say the committee did not win all the battles that it should have in that case, right? I think there's a strong view of the members of the committee, at least at the time, that there was additional unclassified information that remained redacted in that report. But for lots of different reasons, that report needed to get out in December of 2014. And it was sort of the end of the road after arguing back and forth with the White House and the CIA for many months. So the declassification process in regards to the Senate report on the CIA's detention interrogation program, there was, I don't think there was any allegation ever that the committee drew outside the lines in terms of releasing information that hadn't been sanctioned for release by the executive branch. What I think, excuse me, Catherine is referring to is there was a period of time during the writing and drafting of the larger report when we had completed, I think around a 6,000 page report around December of 2012. That report went to the CIA at the request of some of the committee, frankly, of the entire committee. Went to the CIA and the White House for comment, which is, this is a 6,000 page report. These are our findings and conclusions. Let us know where you object, and we will take that on board and change things that we think maybe, the agency or the White House persuasively suggests that should be changed, and the committee would take that under advisement. During that period of time, the CIA pushed back very hard publicly. The committee at this point was still very quiet, did not speak at all publicly about what was going on in the background, but the CIA was not. In fact, the CIA was pushing out stories saying that the Senate report was filled with factual errors, that it was generally wrong. And it came to light during that exchange, that period of time, that the CIA had conducted their own internal review under Director Panetta, who was appointed by Obama. So basically, Panetta wanted to make sure that he wasn't surprised by anything the Senate might find when it went through the CIA's files on detention interrogation, which is a fully appropriate exercise. If I was CIA director, I probably would have ordered the same research. That report was complete. It was over 1,000 pages and was a very damning report to the CIA. And it aligned in many ways with the Senate's findings. That report was generally buried within the CIA, but the committee was provided access to that document. When it came to light at a confirmation hearing, at a public confirmation hearing the committee was having, that the committee had an access to this document, the CIA's own internal review, which found that the program was ineffective, and that the abuse was far worse than what was publicly known at the time of detainees. The CIA searched the committee's computers that were at the CIA to find out how this internal review could have been provided to the committee. They searched the Senate computers, the computers that we used. Obviously, they found this document. And they accused the committee staff of, I do believe they used the word hacking, which is kind of, for whatever reason, inappropriately accessing this document, somehow obtaining this document in some way that wasn't, within the lines of the agreement between the Senate and the CIA. In any event, they brought a criminal referral to the Department of Justice against the staff, which, we always viewed as sort of a last-ditch effort to stop the release of the report. These were, the CIA provided 6.3 million pages of documents. These documents that consisted of the CIA's own internal review that was so damning were quite no different than any of the other documents that we received. And I just presumed that this was sort of the nail in the coffin, so to speak, and that this was the final gasp of the CIA to stop the release of this document by undermining the credibility of the investigators that had been doing this for 6-7 years at this point. The Department of Justice declined to prosecute. The Inspector General then did its own review of the CIA and found that the CIA had fabricated information in the criminal referral, essentially lied to the Department of Justice about what they found with Senate investigators. The Inspector General also found that CIA officers lied to the Inspector General about the process. The Inspector General recommended the CIA set up an accountability board to make sure that people were held accountable within the CIA for filing a false criminal referral against the staff. That board at the time was overseen by Avril Haines, and eventually within inside the CIA, they decided not to hold anyone accountable for that search, which I still think is a pretty dark mark on the Obama administration in general, and also for congressional oversight. The committee did a lot of great work, no doubt, the committee members, and sort of pushing this through and making sure it happens. But I do feel like the committee at some points felt like their hands were tied. And this is one of those cases where there just wasn't a push to have accountability which was a pretty significant threat against checks and balances.
Thanks. One thing I wanted to mention is how all of these different legal arguments and the classification itself, how it delays for such a long time public acknowledgement or even public knowledge of things that should be going on. So the Senate study that Dan worked on started in 2007, is it? And the way we found out initially found out about a lot of what was going wrong in the war on terror was leaks to the press or unauthorized disclosures of some form or another, along with accounts from people who had been victimized by it. And leaking information to the press, which Dan did not do, and most people I know with the clearance have never done. But it does put individuals at risk of prosecution and of surveillance. And so we have a couple questions from the audience about this. And I'm just going to read someone now. Are the panelists aware of being subject to surveillance themselves or among their peers? Are there other subtle forms of coercion that they have experienced from government actors? And I'd also invite you, if not you personally, if it's happened in communities or among people you know, what the experience has been there.
So I can jump in, and I practiced as a civil rights lawyer for just about 5 years, so I have had much less experience than, say, Bahar, who has been doing this for a long time. But even as a civil rights lawyer, you yourself come under surveillance if you are assisting and being with people who are being surveilled or targeted by the FBI. And for me, the incident where I felt this most clearly was in 2005, in the summer of 2005. The government, the FBI, was intensely surveilling the Pakistani community in Lodi, California, which is a Central Valley town. The government, Attorney General Ashcroft, went on national news to say that there was an Al-Qaeda cell found in this small town in California, just about an hour from the Bay Area. And I was a civil rights lawyer at the time, and we heard all these reports of essentially the entire community being under surveillance, with helicopters flying overhead, FBI vehicles in every street, interrogating people left and right. So I was with the Lawyers Committee for Civil Rights. I went down there with a colleague from the ACLU, and while we were there, essentially to speak with people who had been subject to this kind of surveillance and to get a sense of what exactly was going on. And it seemed at the time that the FBI actually took a relish in letting us know too that we were under surveillance. So, their cars would circle us as the attorneys. They would, at one point, the FBI agents would kind of lean out of the window, roll down the window, lean out and snap our pictures. We actually ended up doing a FOIA request to try to get a sense of what they had documented about us. We did a Know Your Rights presentation. Actually, myself and several other Muslim women lawyers went and did a Know Your Rights presentation for the local community at a neighboring mosque. And throughout the evening, we had FBI vehicles circling the mosque in a pretty overt show of surveillance. So, the message to the communities and to us was clear that if you are anywhere near this, you yourself are going to become a target of government surveillance. Just to round out the story, the one person who had been convicted in that case of material support to terrorism had his conviction overturned last year. The grounds were of he didn't receive a fair trial. He didn't have an effective assistance of counsel, but in an opinion that clearly indicated that had the lawyering been different, there was actually a lot of evidence to show that he was innocent. So in any event, I bring that as an example, both to tie it to my earlier point about the pervasiveness of profiling and surveillance within Muslim communities, and also to just answer the point that, yes, I was under surveillance, at least, and that was the time that I knew about it. Let's put it that way.
Bahar, did you have any similar experience? I think you're muted, so I'm going to unmute you.
Oh, thank you. Not as sort of direct and overt as Serene, but I assumed as a lawyer visiting and talking about Guantanamo, I was under FBI surveillance. I think we all operated with that assumption in mind. But, I nevertheless felt a lot sort of safer than our clients. We represented a group of Muslims in New Jersey who were subject to this blunderbuss suspicionless surveillance program by the NYPD. And it's important also, I think, here to recognize the kind of metastasization and the seepage of the war on terror paradigm into municipal police departments that engage in surveillance, and the sort of mass militarization of small police departments, not just, major metropolitan ones from the war on drugs, but the Ferguson Police Department that looked like, a counterinsurgency operation in Fallujah. Anyway, these communities experience the surveillance in obviously a far more terrifying way. I think as a lawyer tied to major institutions, it was uncomfortable, but I ultimately felt safe.
Yeah, and I mean, I think being a racial minority and being in the community makes you much more of a target. The combination of being white and not having a security clearance has made me feel relatively secure through all these years. But if either of those things were different, I would be a lot more uncomfortable. Let me see if there are any other questions from the audience. Okay, good. And have you guys had experience with the government retaliating against whistleblowers and others who were exposing wrongdoing by the government, or do you know of any recent cases of it?
I mean, I think the Obama administration was very aggressive in going after whistleblowers and journalists, I think there are lots of examples of that, and just mindful that that was a sort of particular response of the executive branch when naturally people who were concerned about the massive envelope of security trying to cover up very serious government wrongdoing spoke their spoke their minds and their true beliefs to try and sort of break that up. And the response was to criminalize that activity. I think Chelsea Manning's a prominent example.
Yeah.
I was just going to add that the New York Times Magazine just had a story worth reading about a former FBI agent who worked on counterterrorism in the Minnesota office and earlier in California, who leaked information to journalists about the racial scope of the surveillance that he was being asked to conduct. And he was prosecuted and imprisoned for that. And so I would highly recommend that news story.
Yeah, there was also a whistleblower about the drone program who I think was also convicted early of this year. I think some of the investigations that began under Obama led to prosecutions, or under Trump led to prosecutions later. So to close on a more hopeful note, what are either the most important reforms that policymakers can make to rein in state secrecy, and what actions should members of the public take? Before I ask each of the panelists this, I wanted to plug the Take Action button at the bottom of the screen for anyone watching, which sends a letter to the White House asking them to finally declassify the torture program, and also to try to limit the use of national security secrecy to conceal evidence of crimes or human rights violations. But that said, I also want to give each of our panelists a chance to give their answers. Dan?
Well, I think I'm going to take it in the direction of accountability in terms of the committees. I mean, I think the Intelligence Oversight Committee specifically can be I think they've proven that when they want to be, they can do robust oversight and really provide the counter and the check that it was designed to be. In my own view, and too many times the committees, both in the House and the Senate, become captured a little bit by the agencies they oversee. Perhaps the best example of that is the fact that, the very committee, the Senate Intelligence Committee, that had really worked so hard for 7 years, right, to do what I still think is the largest Senate investigation in history, and produced this report and fought so hard against its own party. It was a Democratic Senate and fighting against a Democratic administration to provide an executive summary to the American people about what happened. It took a lot of effort by that committee to do that, and it was more bipartisan than people might think behind the scenes. But that same committee, this whole effort was launched because of the destruction of videotapes. And there were two people that the CIA and the Department of Justice identified as responsible for those tapes. And one of which was Gina Haspel, who eventually that same committee confirmed under the Trump administration to lead the CIA. So I think, it shows you, in my view, the sort of the best and the worst of oversight. That committee worked really hard to be transparent and get some of the American people. At the same time, it abandoned some of that work when it went and voted to confirm the very person that was responsible for the launch of the Senate investigation. So I guess that's a long way of saying that I think Senate and House oversight are really essential mechanisms to balance the executive branch here, and that they could be doing more, and they're capable of doing more, and they've shown historically that they are that they're able to do this, and I just wish they did it more often.
Thanks. Bahar?
Oh, I was going to turn over. And I think just to tick off some things, accountability. I think the failure to have held Bush administration officials accountable for criminal wrongdoing, either criminally or civilly, is a grievous error. And I think, our tolerances of those outrages and the war on terror made us inoculated to the sort of harder forms of authoritarianism and, enemy bashing in the Trump administration. So I think we want to be mindful of that. I think there's legislation strengthening measures of civil accountability and limiting qualified immunity. And I think, just to come back to my earlier theme, I'm reminded of the statement, what's the best way to avoid war crimes is to stop going to war. And maybe the best way to prevent the slide away from democracy and embrace secrecy in all of these manners is to stop going to war.
And picking up on that, so I would agree with everything that's been said about both congressional oversight, the potential for legislative reform in particular areas, including whether it's state secrets or providing a mechanism for individuals to sue over constitutional violations, sue federal officials for constitutional violations. So all that is there, but it really also does take more fundamental reform. So we have engaged in this 20-year war on terror, and at this point, kind of back-end oversight is simply not enough, or back-end accountability, retrospective measures are not enough to prevent the more fundamental abuses from continuing. So I'll just name a couple of things. Right now, we have an active debate over what to do about white supremacist violence. And there are some on the left who actually prefer to pass new domestic terrorism laws or expand FBI surveillance power, to respond to that threat. And I think the lessons of the last 2 decades and more should suggest that we ought not to expand government powers in those respects, not just because they have the authorities that they need to go after white supremacist or other far-right threats already, but also because the fallout of expanded law enforcement authority historically has been on marginalized communities and communities of color. So that would be one thing, that in our conversations about what to do about new forms of threats or old forms of threats in the case of white supremacist violence, we shouldn't take the view that we can expand government power and authority and then hope to just constrain it at the back end. And we shouldn't stop there at the point of not expanding government authority. We need to also fundamentally rein in the counterterrorism programs that we have adopted for 20 years. Including terrorist watch listing, the broad nature of government surveillance, and numerous other programs that we've adopted.
Okay. Thank you so much to all our panelists, and I hope it was a useful discussion for the audience.